So with all the talk recently about red flag laws, extreme risk protection orders, gun violence restraining orders, doesn't matter what you call them, we're all talking about the same thing. You may have been wondering, like I have, okay, these have been around for a bit in some states like California. How have they actually been getting used in practice? So I read a study that talked about that, so you didn't have to. This is what we're going to be getting into today. So guys, this is going to be really important because I want to set the ground rules for what I'm doing here. What I am doing is I'm trying to bring you information about how this law, the gun violence restraining orders, the GVROs, red flag laws, whatever it is that you want to call them, how these are actually being used in the streets. What I'm not doing in this video is editorializing and going into the extremely important constitutionality concerns. If you want me to go into that, if you want an analysis of this study, let me know in the comment field below. In this study and in this video, I'm just going to be talking about here's what the findings are according to these authors. I'm not endorsing these findings. I'm not saying that their methodology is perfect. They admit to a number of different flaws in them. But again, I read this so you didn't have to. So we're talking about the gun violence restraining order issues coming out of a law that was passed in California back in 2016. California is one of the early states to pass a red flag law act. As of filming this video in 2023, there are currently 19 states and jurisdictions that have these. Now, I have to admit, I'm not a California law attorney. While I am a former state criminal prosecutor and criminal defense attorney, it has nothing to do, thankfully, with the state of California. So all the information I'm getting is coming from this report. So if I'm getting something wrong, look, I'll take responsibility for that right now, but I'm getting it from this report. So my accuracy will be as good as this information is. It seems like the emergency orders that are being issued here are issued largely by officers in the street and in the field, and then signed off by a judge remotely. They tend to be, if not exclusively, single-page petitions with extremely limited case details that are commonly filed with the petitioning law enforcement agency rather than with the court, which of course is part of the problem here when it comes to the fact that, frankly, they're very difficult to obtain through open records requests. No, I'm not saying that's fair or anything of the sort. Again, don't attack me for the way the system works. I'm just trying to bring this information to you. In the first 3 years that the law was passed, between 2016 and 2018, it looks like there were 413 uses of the gun violence restraining order, so the red flag laws. The researchers, as part of this study, could only obtain records for the open cases that I'm inferring wound up going on to a subsequent court date. So if this is working the way that I've seen issues work in other states, there may be an order filed right away in the street. And then the question is you want to convert that temporary order into a permanent order, and that's where things then wound up going to court. As I understood this study, the 213 cases that are analyzed by the researchers are the 213 cases that there were subsequent court dates and files and all that kind of stuff. So right away, that's going to create a flaw in the analysis, which that's not me editorializing. That's me letting you know what they said, because we're talking about the fact that these might be the more extreme cases that are out there. Let's take a look at the information. So according to the researchers, about 54% of the cases involved a documented threat of harm to others alone. So we're not talking about self-harm, we're only talking about harm to others, 54% of the time. Of the cases that involved a threat to others, almost 30% were directed at intimate partners, boyfriend, girlfriend, spouse, that kind of stuff. 23% were at non-family members, 20% at family members, and 9% at someone at school. About 40% of the cases involved self-harm. Most threats were behavioral, and that's 55.4%, and or verbal, 51.5%, and just over 1/3 of the threats involved brandishing or using a firearm. How are they classifying that? I'm not getting into that in this video. If you want to know those details, I don't want to make a 3-hour video, but if you want to know those details, do a deeper dive on this study, let me know. Slightly more than 1 in 4 cases involved threatened mass shootings, which the researchers defined as a threat to shoot an unspecified number of people equal to or greater than 3 other than oneself, including all 6 cases involving minors. So in other words, every single minor case was a mass shooting threat, it seems like. And in each of those cases, 100% of the time, those minors targeted schools with their threats. Nearly 60% of inciting events took place at a private residence, and 24.3% took place at a public venue, including workplaces and schools. Yes, I can do math. I understand that that's only 84%, and that's public and private, so really what's left? Again, don't know. That's what the study said. And it could be that they had difficulty coding that information just because it wasn't there. So my suspicion is it's probably just an unknown. The median age for an individual who was served with a gun violence restraining order was 39, and they were predominantly male. And given the fact that they're defining predominantly male as 93.5%, that seems predominantly male. The known hypothesized risk factors for those involved were mainly drugs and alcohol, about 34% of the time. And drugs and alcohol were directly involved in the event that led to the GVRO about 25% of the time. So in other words, 25% of the time, the person, as I'm reading this, was under the influence or there's some sort of cocktail of drugs and alcohol involved, maybe one, maybe the other, maybe both. And maybe 34% of the time, that's part of their larger picture. Other hypothesized risk factors included the loss of a relationship. So there was some sort of breakup, maybe a divorce, something like that. That's about 23% of the time. Mental illness as well as suicide accounted for about 20% of the time. Now, you may be asking yourself, who is filing these GVROs? Who is initiating these red flag acts? Well, the answer is law enforcement officers, which came both as a surprise and not as a surprise all at the same time. And that's to the tune of 96.5% of the time. Filings by family and household members made up 3.5% of the cases. Petitioners often cited evidence obtained from interacting with the respondent. So keep in mind, almost all the petitioners are law enforcement. So where are the law enforcement officers getting their evidence? They're coming from interacting with the respondent themselves 50% of the time, or information provided by the respondent's family members 32.7% of the time, the significant other 27.7% of the time, or bystanders and witnesses like that 22% of the time in the petition. At the time of the police contact for the GVRO service, nearly 1/3 of the respondents were arrested on criminal charges and or just under 1/4 were placed on an involuntary psychiatric hold. So about 1/3 of the time, they're being arrested for some sort of criminal charge. No information right now as to what that could be, and 1/4 of the time they're taken on an involuntary psychiatric hold. Police use of force, which includes compliance holds, pointing a firearm at the respondent, and the use of less lethal weapons like beanbag rounds and tasers, were noted in approximately 5% of the cases. Now, the 1-year order after a hearing was issued, so let's pause for a moment and explain my understanding of what this is. We have the officer on site at the scene. They're trying to do something to initiate this order. You've got the judge who's being called in. And by the way, judges being called in to issue warrants and that kind of stuff, that is by no means unusual. And if you want to see me do a video on that, let me know in the comment field below. So you've got the judge doing this remotely. They decide, yep, let's roll forward with this. The question though is, does this always turn into a permanent order? The answer is no. There's of course temporary limits on all this kind of stuff, at least as of now there are. And in order to make this something last longer than a temporary issue, it has to go to some sort of hearing, as I'm understanding the California law based on this study. So the question is, how many times does the temporary order turn into a 1-year order? And again, to do that, there has to be some sort of hearing. And it appears that, thankfully, the respondent is allowed to get an attorney to have that be present. Yes, I just referred to attorneys as that. We're entities, we're beings, but attorneys definitely are not people. Just is what it is. Probably telling you nothing new. So we have the fact that in 53.5% of the cases sought, it looks like there was a 1-year order issued. So 53% of the time when a 1-year order was sought, it was issued. It was not issued in 9.9% of the cases where it was sought, and it was not sought in 33.2% of the cases. So backing that up, if we're just playing the statistics, we're not looking at how aggravated or mitigated your cases or anything like that. If you're subject to a red flag, a gun violence restraining order, looks like there's a little better than a 50-50 chance that you're going to wind up losing your right to firearms, or as some would call it, a privilege. Some are not me. About 53% of the time for a year. And if you fight it, you're going to win 9.9% of the time if you're on the street. In court, it means you're going to win basically a little better than 1 out of 6 cases. So it looks like courts are granting just about 5 out of 6 cases, a little less than that, but about 5 out of 6 cases. So that's quite a bit. Petitioners were far more likely to have legal representation than respondents at the hearing for the 1-year order. So that could be playing a factor here. Petitioners had an attorney representing their interests to prevail at the hearing 67% of the time. The respondents who were trying to protect and regain their firearms only 18.3% of the time. Could that be playing a factor in this as well? Probably, but who knows how much of a factor. What's the firearm access and recovery looking like? So based on the information in the court's documents, the majority of the time, 84%, the respondents own a firearm at the time of the inciting event. And a small number had access to another person's firearm. And small does mean small. It's about 4.5% of the time. Or they were on California's fun 10-day waiting period after purchasing a firearm, 2.5% of the time. The firearm removal was documented in 55.9% of the cases, with a total of 653 firearms removed. Of these cases, firearms were primarily recovered by law enforcement, 85% of the time. While most cases with a firearm removal included handguns, a substantial number, according to the researchers, 29%, included what they term as assault-type weapons. Finally, case records indicated that at least one firearm owned by or accessible to the respondent was not recovered in almost 12% of the cases at 11.9%. So guys, I cannot emphasize enough, I am strictly going off this one study to bring you some information, because right now, if you're like me, you really don't know what's going on out there in the street. You don't know how things are being enforced. Yes, we read about cases, stuff like that, but at the end of the day, I'm less interested, well, I am very interested in those one cases, but I'm very also interested in how's this looking if we actually just step back and look at the numbers? That's what I'm trying to do here in this video. There's a lot I can go into as far as the constitutionality issues because they are numerous and serious. And guys, just because I'm not going into that does not mean that I don't have them, because believe me, I do. That's just a separate video if you want to see it. And the researchers in this, again, I have to qualify the fact that according to them, not me, this is a very small snapshot and it's impossible to generalize the numbers. Most of the data came from orders that resulted in a court hearing, which may constitute the more serious cases as noted by the study. Lots of kind of things to be looking at here. If you want to see me go into more studies, because believe me, there's a lot of studies and all sorts of different things out there, let me know in the comment field below. Of course, please show your support for this channel, click like, and as always, we will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.